Hello friends, in the series on the income tax cases, today we will issue a very important point that in case of international transactions where the DRP has given some directions and on the basis of those directions if the transfer pricing officer has passed some order, but if that order is not received by the assessing officer in time, and the assessing officer passes his final assessment order without incorporating the DRP directions through transfer pricing order, then what is the fate of that assessment order? This issue has been taken care in the case of Hitachi Estimo Haryana Private Limited versus Deputy Commissioner of Income Tax, which has been reported in 108 ITR Tribunal, short note 47. And the matter has been decided by Honorable Delhi ITAT I bench and the date of the judgment is 23rd November 2023. In the present case, the transfer pricing officer suggested some upward adjustment in the arm's length price of the assessee's international transactions under section 92CA subsection 3. On the basis of this suggestions for the upward adjustment, the assessing officer passed the draft assessment order which was received by the assessee, and the assessee objected these upward adjustments at the DRP. The dispute resolution panel passed its order by giving some directions dated 23rd February 2022. The concept is this, that when the DRP directions are given, then the assessing officer has to pass the final assessment order within 1 month from the end of the month from the date of DRP directions. In the present case, since the DRP directions dated 23rd February 2022, so the last date for passing the order was 31st March 2022. But this DRP directions, when they were forwarded to the transfer pricing officer and the assessing officer, the transfer pricing officer received these directions and the transfer pricing officer passed the order and gave this order to the assessing officer on 31st March 2022, meaning thereby that the assessing officer received the transfer pricing officer which was based on the DRP directions on 31st March 2022. Since the assessing officer has to pass the final assessment order up to 31st March 2022, so the assessing officer passed the assessment order without following the directions of the DRP through the transfer pricing officer on 30th March 2022 by inculcating a clause that it will be rectified upon the receipt of the transfer pricing officer order. The assessee carried this matter to the Delhi ITAT and the Delhi ITAT said that in the present case, the order of the assessing officer is not valid because it has not been passed by considering the DRP directions through the transfer pricing officer order. But the plea of the department was that since the assessing officer has not received the transfer pricing officer up to the date of passing of the assessment order, so the department should be given another opportunity to incorporate the DRP directions through the transfer pricing officer order. So in the present case, the ITAT remanded the matter back to the assessing officer with the direction that the assessment order should be passed by considering the DRP directions. Friends, my view is that with due respect to the Honorable Delhi ITAT, that the assessee do not have any fault if the assessing officer receives some internal department order late, and the assessee should not bear the burden of that when the assessment order is not passed without following the directions of the DRP, then the assessee should not be penalized by remanding back matter to the assessing officer. It is not the fault of the assessee that the assessing officer has received the order late. So it would have been better if some law is there that if the assessing officer passes the order without following the due procedure, then in those cases, in spite of remanding back the matter, those assessment orders should be declared as null and void. But in the present case, the matter was remanded to the AO for reconsideration. At the end of this video, once again, I am repeating the name of the case. The name of the case is Hitachi Estimo Haryana Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 108 ITR Tribunal, short notes 47, and the matter has been decided by Delhi ITAT I bench, and the date of the judgment is 23rd November 2023.